Professor Levitin, I know that you're also counsel to the Congressional Oversight Panel. It's striking how much we are groping in the dark for information about this, just as we were for the couple years before the financial crisis about how big a deal subprime mortgages and foreclosures really were going to be. And the industry was telling us it was nothing to worry about. It was a mild hiccup. And now we're still trying to figure out, 2 years later, just how big a deal this is. How big a deal is the documentation issues and the requirements of the pooling and servicing agreements, the PSAs, and the put-back liability that may result from not having the documents required by the PSAs. And it again appears that the information is controlled by a party that has some motive to conceal information if it points to insolvency or significant solvency issues for themselves or for an affiliate. Is it a problem with systemic risk or identifying systemic risk that the trustees and the servicers are affiliates of the securitizers of the biggest banks?
It certainly is, and there's a Groundhog's Day aspect of this hearing that we're facing, the same issues we've been facing for the last 4 years in dealing with foreclosures. And it seems like servicers come up and they say, look at all the modifications we've made, even though I think they often double count. Same loan might get multiple modifications. But here we are, every year we have another set of hearings, and there's, we can add another 2 million for foreclosure sales to the count. I think there is a real problem, information problem, as you identify, that the information that we need to evaluate modification programs, to evaluate chain of title issues, so forth, is all in the hands of the servicers who are not going to reveal any of it voluntarily. There is virtually no oversight of servicers. When you hear that there's a trustee, that's not like a trustee for a child's college fund. These are corporate trustees who have very, very narrow contractual duties and no others. They are not general fiduciaries. And they're paid almost nothing, and they have no incentive to look for trouble, not least because they often have very close business relationships with the servicers. So we have a situation where we're not going to get the information unless federal regulators go after it. And there's the problem. And here I very much agree with Professor Saunders. Federal regulators don't want to get this information. They don't want to see if there is a problem because they're too scared that if there is a problem, they're going to have to do something about it. And that's rather disturbing, but basically this is, let's stick our head in the sand and hope that there isn't a problem, because the prime directive coming out of Treasury is protect the banks. Don't let anything happen that will prevent the banks from kind of recognizing their losses over retained earnings over the next decade. And unfortunately, I'm not sure that's a strategy that is really good for the U.S. economy as a whole.